Here is a sound clip of opposition politician explaining Waqf by user to his Muslim audience. The original video footage was telecast on TV.
যে কোনো একটা জায়গায় যদি 20 জন 25 জন 15 জন 5 জন রেগুলারলি নামাজ পড়ে সেটা ওয়াকফ প্রপার্টি বলে ট্রিট করা হবে।
Joydeep, is land grabbing that easy under Waqf by user? Suppose I have an empty piece of land, some few katas or bigas lying idle, and some people starts using it for offering prayers. Can they grab my property under Waqf Act 1995? Muslims are often seen offering prayers in public spaces like roads, rail stations, railway tracks, anywhere. Did they ever claim such properties as Waqf?
Yes, actually, yes.
I mean, just to add, prevailing Indian laws are biased towards squatters. It takes years to remove encroachments from land. What is the legal recourse available if someone claims my property as Waqf? Over to you.
Yeah, precisely yes. Under the present law, which is still operative and which is being proposed for amendment by the 2024 amendment bill by the NDA government. Under the existing law, by claiming user for the purpose of Muslim religious purposes, any land can be claimed as Waqf. And so far your query regarding the legal recourse, suppose if your property is claimed as a Waqf property or my property is claimed as a Waqf property by way of user, like some people is offering namaz there or some people's ancestors were offering namaz there. By this mere claim, a Waqf board can come to a decision that the property is a Waqf property. And you have a very limited recourse to go before the Waqf tribunal, and the decision of the Waqf tribunal will be final. Even the Honorable Supreme Court cannot interfere into this decision. There is only a very limited scope of judicial review. Now, to give a clarity on what is judicial review, I'll give a little more explanation and the system of law that we follow in India in case of general properties. Then it will be easier for the audience to understand where lies the problem. So, under judicial review, the Supreme Court, Honorable Supreme Court will only see whether the Waqf tribunal has followed the Waqf Act, provisions of the Waqf Act to decide that whether a property is Waqf property or not. And the catch is there that the Waqf Act itself is so draconian that it allows the Waqf board to declare any property as Waqf property by saying it is Waqf by user. And please remember one thing, as per this law, once a Waqf, always a Waqf. So I give an illustration. If somebody turns up and files an affidavit before the Waqf board saying that a particular property was used by his ancestors 4 generations back for regularly offering prayer, Islamic prayer, then the board has power on the basis of that affidavit and a survey conducted by the surveyor appointed by the board to declare that property a Waqf property. And once a property is declared as a Waqf property, it is entered into a register of Waqf. You have only 1 year time to challenge that decision. That too before the Waqf tribunal, not before any court of law. And there you have to prove, unlike other laws of India, including other laws governing religious institutions and religious endowments of other communities, Hindu, Sikh, Jain, Parsi, Christians, Buddhist, any other religious denomination in India, they don't have such law, unlike Waqf Act, that where the Waqf board is claiming a property to be Waqf property, the person who is owner or occupier of that property has to go to Waqf tribunal to prove that it is not a Waqf property.